All right, everyone, settle down, please, and let's get straight to it. Welcome, KSLU law students. Now, listen to me very carefully. Today's explainer is not just some casual academic discussion. We are looking at a rigid, structural blueprint. What we're covering today is the exact framework you are going to need to secure a full 16 marks on question 30 of your final examinations covering the Indian Trusts Act 1882, rights, liabilities, and extinction. So I expect you to take notes meticulously, grab your pens, and let's dive right in. Here is exactly how we're going to tackle this. First, the framework of the Trust Act. Second, Part 1, beneficiary rights. Third, Part 2, beneficiary liabilities. Fourth, Part 3, extinction modes. Fifth, our mandatory case law analysis. And finally, a final exam strategy review. I want you to literally write this exact synopsis on the very first page of your answer booklet. It is going to instantly capture the evaluator's attention. Section 1, Framework of the Trust Act. Now, before we even think about delving into the specific sections of the Bear Act, you've got to establish the foundational basis of the Trusts Act in your introduction. Let's look at the cornerstone of this framework. We start with the beneficiary. The definition is, under the Indian Trusts Act 1882, the person for whose benefit the trust is created, holding specific rights and limited liabilities. Now, I need you to write this definition verbatim in your exam script, but let's actually dissect it in our minds for a second. You see, while the trust property is physically held by the trustee, the entire legal framework of this act pivots completely on protecting this one individual, the beneficiary. Their rights are paramount. But as you're going to see very shortly, the law absolutely does not leave them without accountability either. Moving on to Section 2, Part 1, Beneficiary Rights, encompassing Sections 55 through 67. Now, in your exam scripts, make sure you write Part I in block letters, okay? This is the absolute core of your 16-mark answer. Let's break down the statutory rights, Sections 55 through 58. We have the right to rents and profits under Section 55, the right to specific execution under Section 56, the right to inspect accounts under Section 57, and the right to transfer beneficial interest under Section 58. So what does all of this mean practically? Well, under Section 55, the beneficiary is legally entitled to all the benefits that arise from the trust property. It's theirs to enjoy. Section 57, that guarantees transparency. They have an absolute right to demand clear, accurate accounts from the trustee. And Section 58 means their beneficial interest is an actual asset that they can transfer, assuming there isn't an express restriction in the trust deed. Now, when you write this, use precise Indian legal English. Do not paraphrase these headings. Let's look closer at Section 56, Right to Specific Execution. This is defined as the absolute power of the beneficiary to compel the trustee to properly execute the trust. Now, command your pen to heavily underline Section 56 in your notes right this second. It is absolutely crucial. This is, without a doubt, the most critical enforcement mechanism a beneficiary possesses. Think about it. If the trustee deviates even slightly from the settler's original intent, Section 56 is the legal weapon the beneficiary wields to force strict compliance. Furthermore, we have specific enforcement rights. There's the right to sue for breach of trust under Section 60, the right to proper trustees, and the right to compel the trustee to perform their duties. Elaborating specifically on Section 60 here, if you have a rogue trustee who is mismanaging the property, the beneficiary is not just some helpless bystander. No way. They can take direct, forceful legal action to sue for breach of trust and demand proper administration. It's a formidable right, and it ensures the trust remains completely sacrosanct. All right, Section 3, Part 2, Beneficiary Liabilities. Remember what I said earlier? A 16-mark question requires a perfectly balanced answer. In jurisprudence, rights simply cannot exist without concurrent liabilities. If you spend 3 pages writing only about rights, you are going to lose significant marks. Let's read these beneficiary liabilities. First, liability in case of breach with consent, which applies if the beneficiary induced or consented to the breach. Second, liability for benefits received improperly, meaning they must restore the property. And third, liability subject to trust terms. Pay very close attention to the concept of unjust enrichment here. If a beneficiary improperly receives benefits, or let's say they actively collude with a rogue trustee in a breach, they are legally bound to restore that property. The law heavily protects the beneficiary, yes, but it does absolutely nothing to shield them from the consequences of their own fraudulent or improper acts. It's a two-way street. Section 4, Part 3, Extinction Modes. Now, A trust is not some permanent, unbreakable chain that lasts forever. It actually has a very defined lifespan. I need you to shift your focus entirely now because this specific section carries immense weightage in the exam. Here are the modes of extinction under Section 77. Recite these 4 statutory modes strictly in your answers. Number 1, fulfillment of purpose, when the objective is completely achieved. Number 2, purpose becomes unlawful, whereby the trust becomes void. Number 3, purpose becomes impossible. And number 4, revocation of trust under Sections 78 and 79. You see, the law fundamentally abhors perpetuity without purpose. If the object of the trust is fulfilled, or if subsequent events out of nowhere render the purpose unlawful or physically impossible to carry out, the trust is immediately extinguished. Boom. Done. It ceases to exist in the eyes of the law. Now, observe these comparative rules of revocation. On the left, revocation is allowed by consent of all beneficiaries, if the trust is explicitly revocable, or by the settlor in certain cases. On the right, revocation is not allowed for irrevocable trusts or where beneficiaries do not consent. Listen to me. I want you to draw this exact differentiation matrix right in your answer script. A strict KSLU evaluator is going to instantly award you marks when they see complex textual data organized into a stark, unambiguous comparative table just like this one. It shows real clarity. Let's look at a classic statutory illustration. Step 1, A creates a trust specifically for educating B. Step 2, B completes their education successfully. Step 3, the trust is completely extinguished. Make sure you walk through this step-by-step logic flow right on your exam paper. Providing illustrations directly from the Bear Act is absolutely mandatory for scoring top marks. And, contrast this simple fulfillment with a scenario where A creates a trust for an illegal purpose, like smuggling contraband. In that case, the trust doesn't even begin. It immediately becomes void. Always anchor your theoretical points with these statutory illustrations. We arrive at Section 5, Mandatory Case Law Analysis. Listen up, because an answer in a KSLU exam without case laws is simply a failed answer. It shows a complete lack of practical application. Prepare to write down these exact citations precisely. First, our landmark case, State of UP versus Banzidhar. Draw a literal box around this case name in your notes right now. This is a massive precedent explaining the rights of beneficiaries and trustee obligations. To deepen your analysis, you must explicitly detail the brief background. Essentially, this case involved state intervention to ensure that trust properties and public endowments were not being mismanaged. And what was the final ratio decidendi? The court established that the trustee holds strict, unshakable obligations to administer the trust meticulously, which firmly affirms the beneficiary's absolute right to demand proper administration. In your exam, you must explain its absolute relevance to Section 60. Why does it matter? Because this case is the judicial backbone of a beneficiary's right to sue for breach of trust. Write this in a separate boxed format to instantly capture the evaluator's eye. Next up, landmark case, CIT versus Camellini-Cattau. Underline this citation heavily. This case clarified beneficial interest and its enforcement. For your deep case law breakdown, detail the facts for the examiner. This was an intense tax dispute involving the Commissioner of Income Tax, assessing the exact nature of a beneficiary's income. The Supreme Court's ratio decidendi here definitively clarified what actually constitutes a beneficial interest. The court ruled that a beneficiary's right to receive income is a concrete, legally enforceable interest, not just some mere theoretical expectancy. Now, this precedent is exceptionally vital when you are discussing Section 55, the right to rents and profits, and Section 58, the right to transfer beneficial interest. Explain to the evaluator exactly why it matters. This ruling transforms a theoretical right into a taxable, actionable reality in the real world. Finally, Section 6, Final Exam Strategy Review. We are now transitioning from the strict black-letter law to the structural summary required at the very end of your exam script. Please, do not just stop writing abruptly after the case laws. You must conclude with absolute authority. Here is your concluding summary. Transcribe this verbatim into your notes. Point 1. The beneficiary enjoys significant rights to ensure proper administration of the trust. Point 2. The beneficiary also bears limited but undeniably strict liabilities. Point 3. The law provides clear modes for extinction to ensure trusts do not continue beyond their purpose. A strong, decisive conclusion ties the rights, the liabilities, and the extinction modes neatly together in a bow. It proves to the examiner without a shadow of a doubt that you possess complete conceptual clarity of the entire Indian Trusts Act framework. So, the final question stands before you. Are you ready to defend these statutory principles in your final KSLU exams? You now possess the rigid structure, the precise statutory sections, the liabilities, the extinction modes, and the mandatory landmark cases. Review this blueprint, memorize the framework, and go execute the perfect answer script. Class dismissed.